Hello and welcome to the Patent Agent Preparation Series. I am Priggya Arora, an engineer turned intellectual property lawyer, and in this video we'll study about patent filings. So in the last lecture we studied about the patent grant process, and I told you that there are 4 basic steps that we need to take care of during this process. So first is the patent filing, second is patent publication, third is patent examination, and then we have grant and the post grant process. So specifically today we'll study about what is patent filing, what are the forms required, what are their timelines, and probably we'll have 2 videos on patent filing. In the next video we'll study about what is patent specification, what are the requirements of the specification and the claims. So let's start with section 6, which is one of the important section for the purpose of probably an objective question or a subjective question too. So this section is who can file a patent. So specifically in this section, we have 3 subsections, which says a true and first inventor can file a patent for the invention. An assignee of the true and first inventor can file. And third is legal representative of any deceased entitled to make such application. So these are 3 people who can file a patent for an invention. Now we need to know subsections or the sections which relate to this definition. Like in the last class also I told you, whenever we see a term, we try to see whether it is defined elsewhere in the act or not. So when we come to true and first inventor, we have section 21Y, which says true and first inventor does not include either the first importer of an invention into India or a person to whom an invention is first communicated outside India. Now, what does this mean? This means an inventor can apply for a patent. Who is an inventor? Inventor is always a person. Inventor cannot be a company. Inventor has to be a person who has developed the invention. So that person can apply for the patent, and it does not include someone who has imported an invention from other country or someone to whom an invention was disclosed from other country. So it has to be a person who has developed the invention in that jurisdiction, or specifically a person who has developed an invention, but does not include importer or communication from outside India. Second, we have assignee of true and first inventor. Now here it's important to understand the term assignee. Assignee is defined in section 21AB, and it says assignee includes assignee of the assignee and legal representative of a deceased assignee. So who is an assignee? First, let's try to understand who is an assignee. Now, for example, I am Priggya Arora. I work for PA Legal and I have developed an invention. And I want PA Legal to hold commercial rights of the invention. I don't want to hold in commercial rights of the invention. Then I will assign my patent or my patent application to PA Legal. Who holds the right? PA Legal holds the right. Who has right to earn benefit, commercial benefit of the invention? PA Legal has it. Now I will be named as an inventor and PA Legal will be named as an applicant, and applicant is also the assignee. So whenever we have a doubt like who has rights on a patent application, either applicant or assignee has the rights of the patent application. As an inventor, I do not have any right on the patent application. So that's why it's important to understand the term assignee, and it includes, for example, now PA Legal assigns it to somebody else, then that person can also be an assignee. Or if I die, then my legal representative can apply for the patent application. Then it's called legal representative of a deceased assignee. So next we have legal representative of any deceased entitled to make such application. So this means legally to whoever the estate of that the estate is transferred, that person is liable to get a patent. So for example, we have a person X and he has the son Y. So if X dies, then Y can apply for a patent. Why? Because after the death, son has the legal right to apply for a patent. So Section 2(1) case says legal representative means a person who in law represents the estate of a deceased person. So 3 persons can apply for the patent, which is true and first inventor of the invention, assignee of the true and first inventor, and legal representative of any deceased entitled to make such application. Now, first, it uses the term person, any person which includes XYZ. Then what does the term person mean? So person is defined in section 2(1)(s), which includes the government. So that means if there is an invention which is developed by the government can also be the assignee, true and first inventor, or legal representative. Like person can also include government. So now, for example, there is a patent application and there is a dispute on who is the applicant of the patent. Or, for example, 3 people are holding rights on the patent, people X, Y, Z, and Z dies. Then who will hold right of that patent? So to tackle all this situation, we have substitution of applicant clause in section 20. For that, whenever there is a situation, then controller has right to make orders regarding substitution of the applicant. And when will controller make such orders? He will only make when he receives Form 6. So when we read Form 6, we have to read it with section 20 and rule 34, 35 and 36. And what is the heading of Form 6? It is claim or request regarding any change in applicant for a patent. So if there is a dispute or if there is no dispute, still applicant needs to be changed. Then also we have to submit Form 6. Whenever there is change in any applicant, like we want to change X, Y, Z to X and Y. First 3 people were holding rights, now 2 people are holding rights. Whenever there is change in applicant, we have to give Form 6. And if there is a dispute also, for example, X and Y are fighting among them who is the applicant, or X has applied for a patent and Y want to name himself also as an applicant. Then also there is a dispute between X and Y. Then also controller has right to make orders regarding who is the owner of the patent application, and such orders can be made under section 20 and we have to submit Form 6. So next, which is very, very important, and I think once in one of the examination, a question also came, what are the types of patent applications under the Patent Act? So a subjective question may come, and even there is a lot of scope of many objective questions from types of patent applications. So this is also one of the most important topics. And we'll start with ordinary application. So what is an ordinary application? An ordinary application is an application which is first filed in India. It can be a provisional application or a complete application. Like we studied, there are 2 types of patent application: provisional application and complete application. So if there is a provisional application, we have to give a complete application within 12 months. Otherwise, my patent will be considered as abandoned. And if I am making complete application, that can directly be processed. So ordinary application is an application which is filed in India first without claiming priority from any other application or an application filed in any other country. I am filing an Indian application for the first time. It would be considered as ordinary application. Now, what is the important section for ordinary application? It comes under section 7. So it is an application which is filed in India without taking priority from any other application. Then we have convention application. So it is filed in India claiming priority date from a it is an application filed in India claiming priority from date of filing in any other convention country. So there is a treaty called Paris Convention. So Paris Convention has number of countries which are part of that treaty. Whenever I file an application in any of the country which is part of Paris Convention, I can claim the same priority date and file an application in India. And this has to be done within 12 months. If I do not do within 12 months, I cannot claim priority. So to claim priority, I have to file the application within 12 months of earliest priority date. So in that situation, when I file a patent application claiming priority date from an application which is filed in a country which is part of Paris Convention, then it is called a convention applications. And convention application is the term defined in section 135. Then we have divisional application. Divisional application is mentioned under section 16. What happens is whenever we file a patent application, it has to relate to one invention only. This is called as unity of invention. This requirement is called as unity of invention. Why? Let me explain unity of invention in a detailed manner. So for example, I have a mobile phone and the mobile phone has two qualities. One is because I have a special type of charger, the battery life of my mobile phone is increased. I have a special type of battery, the battery life of my mobile phone gets increased. So one can be this invention. Other invention could be the display gives me a better view of the applications of the whatever I use in my mobile phone. So one invention could be on display, other invention could be on battery. So when I file a patent application, I can either file it on a battery or I can file it on display if they are capable of working independently. And how do I check that? Maybe I have to ask myself a question. Is it possible to independently copy my display unit without the battery? If the answer is yes, then it is a separate invention. It cannot be the same invention. So if I have two inventions in one patent application, there are again two options. One option is controller will ask me to divide my application into two separate applications, or I on my own can ask the controller that I want to divide my application in two separate inventions. But that needs to be done. And where in the act it is mentioned the requirement of unity of invention, it is mentioned in section 7 and section 10(5). So these are two sections where requirement of unity of invention is present, and the wording used maybe is generally, which I think I'll open the act and show you, that a patent application relates to one invention or a single inventive concept. So these are two places where unity of term requirement is mentioned. And because of that, we have divisional applications, and divisional applications are explained in section 16. Then after this, we have patent of addition. So in divisional application, I am dividing my patent application into two separate applications. In patent of addition, I am adding another application based on my application. So first application is called main application, main invention or main patent. And second application is called patent of addition. When can patent of addition be filed? It can be filed only when there is modification in the first patent. So if I have a patent on one thing and I have done modifications or improvements, then I can file a patent of addition. Some important aspects that we need to remember is a patent of addition will only be granted after granting of the main patent. So if my main patent is not granted, patent of addition cannot be granted. Then patent of addition dies with the main patent application. So for example, I have filed my patent application on 1st April 2023. Then my patent application, main patent application would be valid till 1st April 2043 for a period of 20 years from date of filing. And I file a patent of addition next year, 1st April 2024. Then the main patent, the patent of addition, which ideally, if it is a subject matter of a separate patent will die in 2044. But because it is a patent of addition, it will die with the main patent application. That is, it will die in the year 2043 only. So patent of addition always die with the main patent application. If you remember, see, when you read the act, the language will seem too complicated. But I think it's easier to remember that patent of addition dies with the main patent. So it cannot exist longer than the main patent. So I think it's easier to remember in that sense, and then you can read the sections and understand it better. So this is the patent of additions. And next we have PCT National Phase application, which is also mentioned under section 135. So what is PCT National Phase application? We had convention application where Paris Convention was the treaty. For PCT, Patent Cooperation Treaty is there, which is managed by World Intellectual Property Organization, WIPO. So whenever a patent application is filed under PCT route, where we take India as one of the designated countries, then that application will be called as PCT National Phase application. We'll study the PCT application process also in one of the classes so that you are clear on what is the PCT process. But for now, we need to understand whatever application comes through PCT via PCT route, that is called PCT National Phase applications. And these applications are generally filed within 30 to 31 months. In India, it is 31 months. It is generally filed within 31 months of date of priority. Like in convention application, it is filed in within 12 months from date of priority. PCT National Phase applications are filed within 31 months of date of priority. But these are both there in our act because of foreign treaties. So these are two applications for foreign, like whenever we have an application which claims priority from foreign countries. One is convention application, other is PCT National Phase application. So here one important thing to remember is there are some countries which are part of PCT, which are part of Paris Convention, but which are not part of PCT. There could be countries which are part of PCT, but not part of Paris Convention. So whenever a client comes to you, you should always verify which countries are part of the Paris Convention, which countries are part of PCT Convention. Then only I can give them a format or a roadmap, like how do we file patent application in India. So only if I know that which countries are part of PCT and which countries are part of Paris Convention, I can guide them that, for example, they want to file a patent application outside India, then based on whichever treaty they are part of, we can take a decision and we can guide them. So next we come to filing requirements. So this again is a very, very important question for the purpose of subjective, because in one of the question papers it was asked that what all forms are required for filing a patent application. So, or I think in Viva also they ask sometimes like what are the forms required when I file a patent application. So this is important from that point perspective. Also, it is important. Why? Because these timelines, they generally come for the purpose of objectives. Like whenever we have objective questions, they'll ask you what is the timeline to file form 1, what is the timeline of filing form 3. So you should know these timelines. And I know on the slide I've just mentioned the word 6 months or 1 month or 3 months, but for you it is important to know what is the starting date. Like if it is 6 months, whether it is from the date of priority, whether it is from date of filing, from where the 6 months period begin. So that is also important and you'll have to mostly remember. But to give you an idea, most of the timelines begins with date of priority, and there are some exceptions. So whenever you study a timeline, it could be that it is from date of priority, and exceptions you can remember. So that is also possible. But let us have a look at what all forms are required. So it is very simple to understand. We have to remember form 1, form 2, form 3, form 5, form 26. These are the 5 forms which are required. Then if it is a startup, educational institute, or some other entity which for which the price of the patent application gets reduced because they claim some benefits, then form 28 has to be given. And if we are claiming priority of our patent application from any other country, then priority documents need to be given. But if these two scenarios are not there, then form 1, form 2, form 3, form 5, and form 26 are necessary. Then let us try to understand what are these forms. And before answering this question, I know a lot of people ask me, and I ask a lot of people. Like if you go and give interview in any law firm, any patent law firm, or you go and give interview to probably patent office also, they'll ask you what is a proof of right. I don't know why, but this is one of the important questions which everybody asks. What is the proof of right? What do you mean by proof of right? How can you give proof of right? So this is a very, very important question. And generally people would say form 5 is proof of right, or they'll try to answer what is proof of right, because proof of right is not mentioned in forms anywhere. But we need to understand what is proof of right to answer that which form we have to give in proof of right. So always remember form 1 is proof of right, and it is application for grant of patent. Why it is called proof of right? Because in form 1, we establish authority of filing the patent. That means how do I have an authority to file a patent? How do I have a right to file a patent? That's why it's called proof of right. And generally, people answer this as form 5, but form 5 is the wrong answer. Right answer is form 1. Why? Because an inventor can file a patent application, but an inventor has to mention name of the applicant who is filing the patent application. Either if inventor is the applicant, inventor will say I as an inventor is also an applicant of this patent invention, therefore I am filing a patent for this. Otherwise, the inventor will say I, being an inventor, is assigning my right to XYZ. Therefore, XYZ can file a patent application or hold rights on this patent. So that is the scenario. And I remember in my interview, the examiner asked me if nobody is there to give proof of right, what do we do? Then, then what do we do is basically we give an employment. For example, there I work for PA Legal and I have an employment contract with PA Legal, and in that contract it is written whatever IP is developed by Priggya, PA Legal will own right on it, and PA Legal would be the applicant for that IP. So in that scenario, I can give the employment agreement as well. So if that is the case, like the person is not available, he is not ready to sign, or I cannot have a signature of my right from the inventor. For example, I left the organization and now PA Legal wants to file a patent and I refuse to sign it. So I can show up my I can show up my employment letter, according to which it would be written that PA Legal has right to file a patent. But always we need to give a proof of right, and it is given under Form 1. And if we do not give along with the filing, it can be given within 6 months, but giving proof of right is important. Next, we have complete or provisional specification. Whenever I file my patent application, it has to be accompanied by provisional or complete specification. If it is provisional, a complete specification needs to be filed within 12 months. If it is complete, then a complete specification needs to be given. So these specification will include details of your patent, details of your invention, and we'll study what specifically goes into the specification in our next lecture. Now, the third form is statement and undertaking under Section 8. So Section 8 has 3 basic requirements that we need to fulfill. First is we give a statement whenever there is a foreign application and we are processing an application in India too. It can be filed, foreign application can be filed before my filing date, can be filed after my filing date. But whenever I'm filing an application in India, I need to give Form 3. Details of Form 3 are mentioned in Section 8. And what does it include? It includes a statement setting out details of foreign applications. So in Form 3, we generally give a table and we tell the examiner that, see, we have filed foreign applications in this country. So this is the statement. Now, what is an undertaking? We tell the examiner from time to time, we'll keep you updated on the foreign applications. So whenever there is any foreign application, from time to time, we'll update the examiner regarding what is happening in the US application, what is happening in the European application. Whatever the scenario is, we from time to time, we'll keep you updated on this. So statement was the detailed particulars of the foreign application. The undertaking is from time to time, I'll keep you updated on these applications. And third element is, for example, controller asks me a certain question regarding my foreign application. To that also, I'll reply to the controller. So whenever the controller require me to furnish any details related to a foreign application, I will furnish those details to the controller. So these are the parts of Section 8, and this has to be given in Form 3. So whenever we submit a patent application, Form 3 needs to be given. The timeline associated with Form 3 or statement and undertaking under Section 8 is 6 months. And 6 months from, like whenever we file the application, from that date, 6 months. Or if there is any development in any of the foreign application, within 6 months, I need to update about that development in the patent office. So that is also 6 months. Or if the controller asks me a question, I need to furnish those details within 6 months. So whenever that is the case, statement of undertaking has to be filed within 6 months, and the section is Section 8, rule is Rule 12. Next, we have declaration as to inventorship. Declaration as to inventorship means if I file the patent application, I need to mention who is the inventor. Like I am the inventor, therefore I am filing the patent application. Or I need to give declaration of who is the inventor, and inventor has to state I am the inventor. So this has to be given What are the appropriate sections? Section 10(6) and Rule 13(6). It has to be given within 1 month of date of filing. Next, we have authorization of patent agent. Who can file a patent application? Either the applicant himself can file a patent application or patent agent can file the patent application. So either the applicant himself can file a patent application or patent agent can file a patent application. So whenever a patent agent files an application on behalf of an inventor, the inventor has to give authorization letter to the patent agent, and that letter has to be filed within 6 months. So it is also called power of attorney or authorization of patent agent. Generally it is given on stamp paper. For now we use stamp paper of 100 rupees in mostly all the jurisdiction, but for Maharashtra or whenever we do any filings in Mumbai, we use a stamp paper of 500 rupees. So this is the general practice, but authorization has to be given under Form 26. It is given on a stamp paper, and if company is the applicant, we have to put seal of the company and signature of whoever is responsible for that company. Next, as I told you, whenever there are special cases, for example, small entities, startup, educational institute, for which fee of patent application is lowered, for that, whenever we file anything related to that, Form 28 needs to be given. And so regarding this is fairly very simple, but what are those special entities? That also we'll discuss in one of the lectures. Then we have priority documents. What are priority documents? Whenever I am filing a convention application or I am filing a PCT application, whenever I am claiming a priority date from an application of any from any country outside India, then I have to give priority documents, and those would be considered as a part of filing requirements. So this is all about what all things are required for filing. And remember these forms, this you have to remember, you cannot skip. Form 1, Form 2, Form 3, Form 5, Form 26 in all cases, Form 28 whenever we have a special case, and priority documents whenever we are claiming priority from a foreign patent application. I can briefly discuss Section 7 also, or you can go through, whenever you go through Form 1, you should study Section 7, which is, and as I told you, it has the requirement of what is a patent application, and it has to relate to one invention only. That's why if it does not relate to one invention, we have divisional application in Section 16. Like we just discussed here, like ordinary application in Section 7, but if unity of invention is not there, then we have divisional applications in Section 16. It also says that international application under PCT would be considered as an application under this act. Then normally date of filing of the invention of the patent application is whenever I file my provisional application or complete application, the first filing date among whatever filing I'm doing in India. So if I'm making my provisional application first, then date of filing would be considered as date of filing of the provisional application. If I'm not filing a provisional application, I'm directly filing a complete application, then date of filing of the complete application would be considered as filing date. But whenever there is a PCT application, an international filing date would be given to that application by PCT, that is by WIPO. So I will use that date as the filing date. So this is also mentioned in Section 3. So if there is any assignment of right to apply for a patent of invention, then proof of right has to be given. Like I just told you, like if I am an employee of an organization, the organization can give the employment agreement, and proof of right is always submitted under Form 1. Then applicant and true and first inventor has to be mentioned in the patent application, and every application needs to be accompanied by a provisional or complete specification. Provisional or complete specification is given with Form 2, and the operating sections are Section 10 and Rule 13, which we'll study in the next lecture. And yeah, I think that's all. These are the filing requirements. But once again, to summarize, these forms are very important, and types of patent applications are also equally important. So main things to focus on are the types of patent applications and these form. Types of patent applications are ordinary, convention, divisional, patent of edition, and PCT National Phase application. Forms are Form 1, Form 2, Form 3, Form 5, Form 26, 28, and priority documents. So that's all for today. In the next class, we'll study what are the specifications, the provisional and complete specifications, what are requirements of provisional or complete specifications, and how do we determine priority dates on the claims. So these are basically sections 9, 10, and 11, and we'll study those sections in detail in the next class. So that's all for today. Thank you. See you in the next lecture.